FCA Article 5. The family court has exclusive original jurisdiction in proceedings to determine the paternity of a child born out of wedlock. The Supreme Court retains jurisdiction as a court of unlimited jurisdiction to adjudicate a paternity proceeding, but Supreme Court rarely exercises its inherent jurisdictional powers with respect to paternity. Each parent of a child born out of wedlock is liable for necessary support and education of the child and for child's funeral expenses. Upon a parent's death, an order of support or settlement made prior to the parent's death shall be enforceable against the estate of the deceased parent. An acknowledgment of paternity executed pursuant to the social services law or public health law shall establish paternity of and liability for support of a child. Such acknowledgment must be reduced to writing. A determination of paternity made by any other state must be accorded comity, also known as full faith and credit, in judicial proceedings of one state, shall be respected by each sister state. Proceedings to establish paternity may be instituted during the pregnancy or after the birth, but shall not be brought about after a child reaches the age of 21, unless paternity has been acknowledged by the father in writing or by furnishing support. If the court finds the male party is not the father of the child, it shall dismiss the petition. If the court finds the male party is father, it shall make an order of filiation declaring paternity. Family court has original jurisdiction concurrent with the surrogate's court to determine issues relating to the establishment of paternity in accordance with 111-B domestic relations law. 516-A. An out-of-court agreement acknowledging paternity establishes the paternity of the respondent putative father. The agreement in writing must be filed with the registrar in the district where the child is born. Either party who signed the agreement may challenge the agreement in court, but only on the basis of fraud, duress, or material mistake of fact. A determination of paternity made by another state must be accorded full faith and credit pursuant to the appropriate section of the Social Security Act. Where a signatory has not attained the age of 18 at the time of execution of the acknowledgement, such signatory may seek to rescind the acknowledgement by filing a petition to vacate up to 60 days after turning 18 or 60 days after date respondent is required to answer the petition relating to the child in which signatory is a party, whichever is first. And that was effective 1/19/14.
To get this straight, some guy says, I'm the father. He acknowledges it, right?
Yeah.
Okay, so he acknowledges that he's the father. But then he says, no, I'm not the father, so he wants to vacate that acknowledgement. Is that what this is talking about?
Yes.
Okay, so now he's saying, no, I'm definitely not the father.
He has to say it within 60 days.
No, he didn't sign something.
Yeah, because I think that they give the acknowledgement of paternity, you sign it at the hospital when the kid's born.
Oh, okay. Within 60 days, he can challenge it?
Yeah,
but only if he can say that he was under fraud, duress, or mysterious mistake of fact. And mysterious mistake of fact, what's that? There was 5 guys at the gangbang. It could have been any one of them.
Yeah, I guess so. All right, and then the amendment here, I think it's important because it's pretty new.
What?
Is if the father was only like 16 when he signed it.
Oh, I don't know.
Then he gets 60 days after he turns 18. Or 60 days after he's required to answer a paternity petition, whichever is first.
So can I record me saying that situation to you right now? Article 5 question. An acknowledgement of paternity must be in writing, filed with the register of the district in which the birth occurred. Oh, and you know what I said wrong here?
What?
I said social services and you said Security Act or something. Social Security Act.
Yeah, that's what it says. I could have wrote it down wrong, though, so we should look. 516-A. An out-of-court agreement acknowledging paternity establishes the paternity of the respondent putative father. The agreement in writing must be filed with the registrar in the district where the child is born. Either party who signed the agreement may challenge the agreement in court, but only on the basis of fraud, duress, or material mistake of fact. A determination of paternity made by another state must be accorded full faith and credit pursuant to the appropriate section of the Social Security Act. Where a signatory has not attained the age of 18 at the time of execution of the acknowledgement, such signatory may seek to rescind the acknowledgement by filing a petition to vacate up to 60 days after turning 18 or 60 days after date respondent is required to answer the petition relating to the child in which signatory is a party, whichever is first. FCA Article 5. The family court has exclusive original jurisdiction in proceedings to determine the paternity of a child born out of wedlock. 521. Venue may be in the county where the mother, child, or putative father resides or is found. A child born outside New York State does not bar a proceeding to establish paternity in the county where the putative father resides or is found, or in the county where the mother resides or the child is found. So that is, mother resides, putative father resides, putative father found, child found. 524. The summons in a paternity proceeding shall contain a notice stating 1. That the respondent's failure to appear shall result in the default entry of an order of filiation. 2. If the court is satisfied he received notice of proceedings, that respondent's failure to appear may result in the suspension of his driving privileges, his state, professional, occupational, and business licenses, and suspension of his sporting license. At this time, commitment to jail is not an option. 525. Service by mail shall be made at least 8 days before the time stated in summons for appearance. Under CPLR 312-A, first-class mail is sufficient. 525. The court allows for personal service or service upon suitable agent discretion in the first instance. Substituted service, aka nail and mail, under 308.4, may only be ordered after a reasonable effort at suitable agent discretion and personal service have failed. Nail and mail is more lenient than the CPLR because CPLR requires a due diligent effort. Service by mail alone is also okay under 525, which indicates that service on a designated agent is permissible if such agent has been agreed upon in writing by the parties. Service by publication is not available under Article 5 of the FCA. 527A and B. A respondent arrested in New York City on a warrant shall be taken before the court that issued the warrant. However, if he's arrested in a county outside New York City on the warrant issued in New York City, he shall be taken before a family judge in the county of apprehension. A respondent taken into custody on a family court warrant issued outside New York City shall be taken before the court issuing the warrant if he was apprehended in that county. A respondent taken into custody on a warrant issued in a county other than the county of arrest shall be brought before a family judge in that county. All right, so let me explain that real quick. So a respondent apprehended in Kings County on a warrant in Queens County shall be taken to the court in Queens. If the respondent is taken into custody in Nassau from the warrant that was issued in Kings County, he shall be taken before a family court judge in Nassau County. A respondent taken into custody on a warrant that was issued in Putnam County shall be taken before the Putnam County Family Court if he was apprehended in Putnam County. A respondent taken into custody in Nassau County on a Putnam County Family Court warrant shall be brought before a family judge in Nassau County, or the Support Collection Unit, but not just any unit from any social services district. The Support Collection Unit shall report to the court as directed the amounts received and paid over. 512. The phrase child born out of wedlock refers to a child who is, quote, begotten or born out of lawful matrimony.
To establish the paternity of a child may be instituted A, during the pregnancy of the mother, B, after the child is born, B, before the child turns 20 unless paternity has been acknowledged by the father in writing or by furnishing support.
It's during pregnancy, after child is born, but not after they turn 21.
Yeah, I tried to trick you. Yeah, I didn't know that. I haven't done these questions. That's why I need to record them and start listening to them in the car.
If a putative father is allowed to intervene in any family court proceeding, the court may issue an order of filiation.
At the time he intervenes?
You want me to just read the answer?
Yeah.
Okay. 1, if both parents are present. 2, if the father waives the filing of a paternity petition. 3, if the father waives his right to a hearing. 4, if the court is satisfied as to the paternity of the child from testimony of the parents.
Hold on, I'll read it to you right now, see what it says.
I mean, I could be wrong because I'm looking at my notes.
I'm going to read it. It's a very small section.
Okay.
Proceedings to establish paternity may be originated in the county where the mother or the child resides or is found, or in the county where the putative father resides or is found. The fact that the child was born outside of the state of New York does not bar a proceeding to establish paternity in the county where the putative father resides or is found, or in the county where the mother resides or child is found.
Okay, so it's, if the child is born out of the state, it's only where the mother resides. And it could be where the child is found or...
Wait, I thought it just said where the mother resides.
Yeah, it's only, but it's not where the mother is found.
It says the mother resides or the child is found.
Right.
Oh, that's tricky.
Yeah, it's very tricky wording. That's why I want you to be careful.
Oh, let me read it again. That's just that sentence.
Yeah.
The fact that the child was born outside of the state of New York does not bar a proceeding to establish paternity in a county where the putative father resides or is found, or in the county where the mother resides, or the child is found. Oh my goodness,
This is only out of the state. If it's in the state, then it could be where the mother is found. But if it's out of the state, it's where the mother resides.
So it's going to read like this. The fact that the child was born outside of the state of New York does not bar a proceeding. What does not bar a proceeding mean?
It means it doesn't prevent a proceeding.
Okay, so does not bar a proceeding to establish paternity in the county where the father resides or is found, where the mother resides, or the child is found. But I don't understand. They can or they can't.
Okay, so this is how it works. If the child is born in New York, the proceeding could be wherever the mother, father, or child resides or is found. If the child was born in Georgia and then the mother moves to New York, the mother moves to Nassau County, but the child is living with grandma in Queens, the proceeding can't be where the mother is, quote, found. If venue is based on the mother, it would have to be...
it says where the mother resides. Oh,
right, where she resides. Have to do it in Nassau if it's based on the mother's residence. If they're basing the venue on the mother, they have to do it where she resides.
So the mother lives in Nassau. I'm the mother.
Yeah,
I'm the mother. I live in Nassau.
Okay, yeah.
But the baby was born...
Born in Georgia.
I moved here with my little rugrat to Nassau County.
All right, DSS wants to start a proceeding. Now grandma takes the baby to her house in Queens. Maybe not to her house in Queens, but to Georgia. Money that they paid out to you while you lived in Nassau. They don't even have to find the kid. They just have to commence the proceeding based on your residence. They have to do it in Nassau if it's based on your residence.
Where the mother resides.
Where the mother resides.
But then it says where the child is found.
Right. So if they if the child is found in Queens, they can do it, but the venue would be based on child being found there.
Oh, okay.
All right.
So they can do it in either or, but the mother has to reside in that residence, and the kid has to be found in New York. When I said proceedings to establish paternity may be originated in, they're talking about in New York.
Yes, when the baby's born in New York.
Where the mother, child resides is found, or where the father resides or is found.
Yep.
But if it's out of New York, it's where the father resides or is found, where the mother resides, or where the child is found.
Perfect. You got it.
Got it.
Scenarios really help me. That's why I have baby Tanya Harding.
Totally. But it'll help even when I'm in the car and I'll be remembering this conversation, Bahamas and listening to this crap.
Oh my God.
All right. The next question is proceedings to establish paternity of the child and to compel support may be commenced by. Now, the other Article 4, when it says who can bring an article for support, That was the father, the mother, the child, a relative, somebody in the mental hygiene, and somebody in the social services.
Because I have a 2017 book, okay? 522, person who, oh my God, I'm starting over. Persons who may originate proceedings. Mother, whether a minor or not, by a person alleging to be father, whether minor or not, by child, or child's guardian, or other person in local parental relation, or being the next kin of the child, by an authorized representative of an incorporated society doing charitable or philanthropic work, or if mother or child is likely to become a public charge on a county, city, or town by a public welfare official of such county, city, or town where mother resides or child is found. I had a gangbang with 3 guys. They do a petition against the first 3. It doesn't dismiss with prejudice to the other 2 guys of the gangbang.
Oh, okay.
All right, so let me do this real quick one more time, and then I want you to do 4. So this is 522, persons who may originate proceedings in paternity. Mother, father, mother, alleged father, child, child's guardian, person in loco parentis, next of kin to child, authorized representative, charitable philanthropic work, or if mother or child is likely to become a public charge on a county, city, or town by a welfare official of such county or city or town where mother resides or child is found. If a proceeding is originated by the public welfare official, it's not on the merits, it's not with prejudice as to other persons. Go.
Article 422, who may originate a support proceeding to compel a person chargeable with support to support the petitioner as required by law. The husband can, the wife, the child services official, commissioner of mental health.
All right, so there's 6, and then
6.
how many?
There's 1, 2, 3, 4, 5, 6, 7, 8.
All right, so there's 8 for the Article 5 and 6 for Article 4.
Yeah. Of a verified petition alleging that the person named, either respondent or petitioner, is the father of the child, and they're petitioning the court to issue a summons or a warrant requiring the respondent to show cause why the declaration of paternity, order of filiation, order of support, or other and further relief prayed for by the petition should not be made.
All right, so... Oh my God.
You're going to remember this now. When you listen to it, you're going to be like, oh,
all right, I'm recording again. Let me start over. Okay. Nothing in Article 5 gives court power to place or board out a child to an institution. However, the court may award custody of the child during a term of an order of protection to either parent or a relative within the 2nd degree of kindred.
The summons shall contain or have attached thereto a notice stating the respondent's failure to appear shall result in the default entry of an order of filiation by the court upon proof of respondent's actual notice of the commencement of the proceedings, and B, the respondent's failure to appear may result in the suspension of his driving privileges and state licenses and stuff.
525. Personal service of the summons and petition shall be made by delivery at least how many days before the time stated therein for appearance?
8. And also Article 4 is also 8.
Good. Wait, start over. I'm going to record you saying this.
It's the same thing. It's the same thing. It's the 4 things. Suitable age, the person of suitable age, the date, time, and place of service.
Okay.
Respondents to obey a summons, the court will enter an order of filiation by default. The respondent shall have the right to make a motion for relief from such default within 1 year from the date such order was entered. Remember, in civil, it was 1 year.
So they're treating an order of filiation as the same thing.
Yeah, because he didn't respond to the summons, and he could, even though there's proof of service, I guess he could say, there's always proof of service in civil, too.
Yeah. Okay, so for the order of filiation, he's got 1 year, but if he signs an acknowledgement of paternity, it's only 60 days.
6 days, right.
So this one is if he didn't even know that there was a kid, or he had no idea that, it was his, and then the court orders the filiation, and he has a year to be like, wait a minute, I don't know if I'm the father.
Right.
But if he actually signs an order of affiliation,
Duress, mistake of fact, and the other one, fraud. The thing is Article 4. The court before whom the respondent is taken pursuant to a warrant may be required to place an undertaking to appear, or in default thereof may place the respondent in custody. And then the trial shall be by the judge without a jury, and the mother or the alleged father shall be competent to testify, but the respondent shall not be compelled to testify.
Okay.
All right, you want me to read another one?
Yeah.
In a paternity proceeding, the court may permit a party or a witness to be deposed by telephone or audio means or other electronic means at a designated family court or other location, and it's the same list where the party resides, other than the county where the family court is, or where such party or witness is presently incarcerated on the date of the hearing, or where the court determines that it would be undue hardship. Okay, we got that.
All right, I got one.
Questions on my test.
I got one.
Go ahead.
If there's service by mail alone, it shall be how many days before the time stated for appearance?
8.
Yup. So I guess they don't give extra time.
888. If an adjournment is granted upon the request of either party, the court may require the respondent to blank for appearance.
Give an undertaking?
If an adjournment is granted by either party, by the request of either person, the court may require the respondent to give an undertaking. That's interesting, huh?
Was that the answer?
Yeah.
Oh, I totally just guessed.
If the petitioner asks for the for the adjournment, the court may require the respondent to place an undertaking.
Wow, that's crazy. So even if the other side asks for it, they still might have to.
Yep.
Oh.
Yep. And then my next question is, if the court finds that the male party is not the father, it shall dismiss the petition. And then if the if the applicant or recipient of a family assistance is pregnant, and the proceeding to establish paternity has been filed, and the allegations of paternity is denied by the respondent, there shall be a stay of all proceedings until how many days after the child is born?
I fucking read this too. Ugh. I'm gonna guess. If the pregnant woman is on family assistance, there's a woman's getting public assistance.
Right.
And there's a paternity petition commenced, it's stayed until 60 days after the child is born.
Right.
Okay. All right.
That's it for my test 5. We did good.
All right. So,
A?
I have more.
Did we do 5B too?
No, we didn't do 5B yet.
Should we though?
Yeah, we're gonna definitely do 5. We gotta do 5B. I gotta figure out how to pull up my questions, because my questions, I didn't print them. They're typed on my iPad for my 5B questions.
You want to go do some stuff on your own? I'll make my video from 4 and 5, and then we'll meet up and do 5B.